Hello and welcome. I'm Peter Afrasiabi, and today's program revolves around the Michael Avenatti trials. It's getting stormy out there. This is part one of what will be a two-part program series. Part one will take us to the East Coast, to the two trials involving Michael Avenatti and the highly publicized events revolving around his representation of Stormy Daniels, which led to a criminal indictment of him, and the case involving Nike, where he was also criminally indicted in the Southern District of New York for federal criminal violations in that case. All of these cases of Michael Avenatti have been obviously highly publicized. They're well known in conventional media, but certainly within legal circles. And so they provide a very useful petri dish for us to look at the ethics issues that sit beneath. Now, obviously, the ethics and the criminal law violations heavily overlap. But this program is not about criminal law. It's not about the intricacies of mail fraud, honest services fraud, and the different federal crimes. This is about looking at the underlying ethics violations that also occurred when those criminal violations occurred. And so part one will focus on the East Coast. Watch part two, and we'll shift to the West Coast, where the West Coast trials are set to unfold. Let's start on the first slide with Icarus, because Icarus is a very useful metaphor for lawyers when we're thinking about ethics transgressions. Icarus, of course, is the famed figure from Greek mythology of the boy who was given flight by his father to escape the island. He had wings made of sort of wax and feather so that he could fly, and he had this incredible opportunity to fly, but he was warned, don't go too close to the sun. He went too close to the sun, the wax melted, he crashed into the sea and died. And so the story has itself become a metaphor for the need for balance, equilibrium, humility, caution. The allure of certain things can be so great that it can lead us to take dangerous steps that sort of violate, for Icarus, the laws of physics and gravity and heat and whatnot. But for lawyers, it's fantastic as a metaphor because it revolves around the idea of these legal boundaries which operate like the sun for us. You get too close, you get burned. And so Icarus as a metaphor has found its way even into the ethics case law, and here's a good case that we can start with. In re Adams from the Northern District of Texas in 2020. And this case involved criminal investigation where, as the government was doing its investigation, it became concerned that Attorney Adams had some sort of an intimate relationship with her client Spearman. And this then came out, and the attorney then accused the government lawyers of all manner of things. Racism, claimed that they were behaving unethically. She filed grievances with the state bar, which was denied, and made some sort of a social media post about government lawyers in the case. She accused a DEA agent of perjury and a whole variety of things like that. And so this worked its way up to an ethics charge, ultimately, that got adjudicated by the judge. And the court indicated that, the Attorney Adams committed some misconduct, and it was sanctionable under some of the local rules as unethical behavior. And in so holding, ultimately, it used the Icarus metaphor. And as the court said, it appears that, like Icarus, she has flown very close to the sun at times. Perhaps Ms. Adams will now realize that she ought to orbit a little farther from the sun so as not to get burned. That metaphor and that principle is what animates this presentation today as we look through the Michael Avenatti trials in terms of what happened. But it's a very useful one to keep in mind because these ethics transgressions can occur every single day in any court in the country. It's not just limited to the extreme or unique facts of Mr. Avenatti's case. It's all manner of behavior, like this case we just saw. And these ethics rules really function like the sun. We have to become, as lawyers, ever vigilant about not getting too close to getting burned on them for fear of the recourse. So let's get started talking about what are the issues we're going to look at today. We're going to look at the ethics and legal charges as it relates to lawyering and then over-lawyering and these advocacy rules through the prism of the two East Coast Michael Avenatti trials. We're going to look at the Nike trial and the Stormy Daniels trial. And so we're going to look at what happened in those cases and understand those criminal cases in terms of what happened in order to then look at the facts as found ultimately by the jury in those cases through the prism of the ethics questions that we're going to look at. We're going to look at the ethics rules on advocacy, threats in representation for leverage or over advocacy, and the damage to a client that comes, and then the damage to the lawyer for those violations. We also will do a little stop on the ethics rules for client money handling and the importance of that. And along the way, we'll of course pick up some other case examples that we can just look at to flesh out these lines that sometimes are blurry in the different cases. So the major ethics rules on the next slide you see here that we're going to address today are ones relating to threats and extortion. When does a lawyer's behavior in litigation or pre-litigation, when does a lawyer's advocacy and zealous representation of a client cross a line from that advocacy that's permitted to an unpermitted threat, or what's in the criminal realm defined as extortion? And we'll look at cases on either side of that line to understand where that line is better, to make sure that we all keep a very safe distance. We don't get too close to that sun. We'll also look at the duty of loyalty to the client and the ethics, fundamental ethics rules that relate to our duties as lawyers of loyalty to our clients to come first. We'll look at the legal and ethical issues and rules built around falsification of settlement documents, forging client signatures, and then we'll look at client trust account cases and issues that revolve around stealing client funds, maintaining money in trust accounts, and the critical ethics rules that apply there that are very bright line rules. Let's get started now with the fact pattern from Michael Avenatti in both cases. And I want to give you kind of a highlight overview of each of the fact patterns in terms of what was going on here that led to the criminal indictments and these ethical problems that Mr. Avenatti found himself in these cases. And so the first one is obviously the famous case everyone knows probably, but you need a recap in case you don't. And this involves Stormy Daniels and President Trump. And so what basically happened is Mr. Avenatti starts representing the former adult star Stormy Daniels in a piece of litigation against President Trump based on her attempt to unseal her confidential agreement on a financial settlement that had been occasioned by alleged liaisons with President Trump. And so this was sort of being sought to be unmasked in order to explore, the relationship between, whatever the settlement was and campaign disclosure violations and the like. And so in process of representing Ms. Daniels in this case, Mr. Avenatti became obviously an incredibly famous lawyer. It was reported he was on television 254 times in 1 year, which is, literally almost every day. 2 out of 3 days he was on TV. Hundreds of thousands of followers on Twitter, and he became a very famous national, legal celebrity. And he was, taking on President Trump. There was talk of him running for president, and I believe he even may have had some exploratory committee looking at it. And so it's out of that situation that Stormy Daniels then gets a book deal to talk about sort of her life story and what happened there, right? Because she's now become a very, very prominent public figure also. And so it's the book deal that leads to the ultimate trial that matters for Mr. Avenatti and for our ethics questions today, because Attorney Avenatti helps Stormy Daniels negotiate her book deal, gets, deals with her publisher, and then the money starts flowing from the publisher, and that leads to sort of what happened. And so it's that representation of Ms. Daniels on her book deal that's the factual core of the ultimate ethics issues. It's not his representation of her in the unsealing of the documents and the battles that revolved around that. That didn't involve any ethical violations or charges that are a part of anything. It just didn't happen there. So it's only in the book deal. Now on the Nike side, in around the same time period as Mr. Avenatti has this sort of national fame, he is representing a client who has an amateur team's sponsorship canceled by Nike. And the client believes that the Nike employees wanted him to do corrupt acts relating to paying youth sports athletes. And so Mr. Avenatti, with his co-counsel, Mr. Gallegos, go to Nike with a financial demand for their clients. And Mr. Avenatti then, in the context of making that financial demand and the back and forth with the lawyers for Nike, indicates that he will use his public persona to damage Nike's market cap with allegations of financial wrongdoing in sports deals. And that then leads to the criminal indictment in the Nike case. And so we're going to look at both of these in a little more detail to unpackage what happened. But first of all, on our next slide here, we're going to listen to a couple recordings, because these are recordings, and we're starting with the Nike case today. These are recordings that were made by Scott Wilson of the Boyce Schiller firm, who was representing Nike, of his conversations and interactions with Mr. Avenatti and Mr. Egregious, who were representing their client. And so let's listen to the first one for 2 minutes, because it's these recordings that are fundamentally the evidence that the government used to substantiate or justify its criminal contentions against Mr. Avenatti in the trial. So let's listen to the first one for 2 minutes.
What do you mean the number? What do you mean I think I only threw out one number.
The request, the settlement, the what you asked for. I didn't mean to be unclear. What are you referring to?
Well, Scott, I mean, look, I mean, we're going to get $1.5 million for our guy, and we're going to be hired to handle the internal investigation. And if you don't want to do that, we're done. I mean, this isn't that time. No, just listen. Go
ahead.
I want to be really clear with you. Okay. I'm not fucking around with this, and I'm not continuing to play games. And I don't, this isn't complicated. You guys know enough now to know you got a serious problem. And it's worth more in exposure to me to just blow the lid on this thing. A few $1 million doesn't move the needle for me. I'm just being really frank with you. So if that's what is being contemplated, then let's just say it was good to meet you, and we're done. And I'll proceed with my press conference tomorrow, and I'll hang up with you now, and I'll call the New York Times, who are awaiting my call. But I'm not fucking around with this thing anymore. So if you guys think that, we're going to negotiate $1.5 million and you're going to hire us to do an internal investigation, but it's going to be capped at $3 or $5 or $7 million, let's just be done.
So, Michael, I hear you.
And I'll go take $10 billion off your client's market cap. But I'm not fucking around.
Michael, I hear you. You did put a number.
No, I don't think you do. I don't think you hear me. Look, I think maybe you hear me, but I don't think you're listening. And I don't think you understand the importance of what I'm talking about. You guys were given a lot of information the other day.
So now you've got the first one in mind. Let's listen to the second one. And before we listen to the second one, just so you know, I have the links there for you. You can take those links yourself and go listen to all of the sound recording if you want, or these portions as indicated here on the slide that I excerpted for you, because these seemed the most relevant ones, but you're welcome to listen to all of them, of course. They're available online. But now let's listen to this second recording, which is a snippet, as you see, of about a little over 3 minutes taken from a couple places in the file. So go ahead and listen.
Want to do that? I think.
So tell me what.
I'm going to put my Nike hat on. Okay. Just for the sake of argument, I'm going to put my Nike hat on.
It's got a swoosh and everything.
Right. It has the original.
Go on.
I put on my Nike hat. I know why that question is being asked. Can I be so bold? You don't have to answer this question. They want to get rid of this in one fell swoop or swoosh and not have it hanging over their head. So
well, they're going to have to do an internal investigation anyway. But let me just say this, okay? I don't think that it makes any sense for Nike to be paying an exorbitant sum of money to Mr. Franklin in light of his role in this.
okay.
I mean, imagine that.
Widespread than we even suspect. It would be a good idea, I think, to root it out and fix it. Don't you think? I mean, just conceptually. And so the idea of, and by the way,
look, I know for a fact that these aren't the only payments, and I know for a fact that the payments didn't only go through California Supreme Court.
I've never gotten a $12 million retainer from this client.
yeah, but your firm.
Guess what, if you ever
I know how much
balls with a client in your hand where you could take $5-6 billion of market cap off of? This is gonna be a major fucking scandal. You said yourself that you're surprised Adidas wasn't indicted. I'm gonna tell you, if we don't figure this out, from moment one, I'm gonna be asking why Nike hasn't been indicted.
Well,
I'm gonna bring the power of my platform to bear to expose what the fuck is going on here appropriately. If we can't reach a settlement in connection with this, and there's nothing wrong with that. I mean, Nike has their platform. I have my platform.
Okay.
So look, I mean, it doesn't, you know, is it a lot of money? Sure. Is it a lot of money in the grand scheme of things? No.
I've seen some press conferences in my day. I've seen some of your press conferences. I'm not sure I've seen a $25 million press conference.
Okay, let me just explain something to you. This is not going to be a single press conference. Okay?
Are they a million apiece?
No, this is going to be a scandal. It's going to be the biggest scandal in sports in a long time. That's what this is going to be. This is going to be
Okay. Is there room to negotiate on the specific millions we're talking about?
on what?
On the dollar figures that you put on category 2?
So look, I'll say this. If your client wants to have one confidential settlement agreement and we're not, they can buy that for $22.5 million. And we're done.
That's helpful.
Fully confidential. We can leave it to Nike and its other lawyers to figure out what to do with this and handle it appropriately. And full confidentiality, we ride off into the sunset. If you need assistance from us as it relates to...
Okay, so there you have it. Those are the gist of the conversations that occurred in the back and forth in this, conference room in a high-rise tower and, somewhere in downtown New York, in Manhattan. And so this led to a double indictment on the same day for Mr. Avenatti by the U.S. Attorney's Office, because he was indicted both in the Stormy Daniels case and in the Nike case on the same day, and there you have a picture of both indictments. Now, what becomes particularly relevant for how this case ultimately unfolds is that the co-counsel in the case, Mr. Egregious, was not indicted or charged. Only Mr. Avenatti was charged for those phone calls and the issues that happened, as you heard. So now let's take a look at the Nike trial, and we'll unpackage this, we'll peel back the onion a little bit more, and we'll see what happens. And so Southern District of New York holds a trial. The charges were extortion and honest services charges that were federal criminal charges that were made, and the jury convicts Mr. Avenatti. And so at sentencing, ultimately, the judge explains the facts that sat beneath the jury's findings for purposes of sentencing. And these are sort of the major facts that are and become particularly relevant for us as we start talking about some of the ethics issues involved. The client came to Avenatti and wanted to rebuild his sponsorship with Nike and to get the team back and have Nike employees fired. He wanted $192,000 of compensation. Avenatti told him he'd get him $1 million, but also told him that it's unlikely Nike would ever bring him back on board. At that March 19th Nike meeting, and that was part of the audio clip you heard, he told Nike that he had a whistleblower and he wanted $1.5 million for his client, plus he wanted money for the lawyers for an investigation that the lawyers were going to do. They would be ultimately be hired by Nike to investigate Nike, and they'd get paid a bunch of money for themselves. And if not, he'd blow the lid on fraud in amateur sports and as you heard on that audio clip, would take billions off their market cap. Now, he didn't demand employees be fired or that the team be given back to the client. And then on the March 21st audio clip that you heard, Nike asked for a pure settlement with no separate investigation, just a straight up money deal. We don't want you to also have a deal to investigate us and do some sort of internal investigation. Avenatti then says, as you heard in the thing, that it's not worth paying his client more. And then it's the famous comment that's been very heavily publicized in the press, obviously, that he held the balls of the client in his hand. And that comment is a comment that obviously came back to haunt him in the criminal trial and ultimately in the whole scenario. So he's convicted, as you see on the next slide here, of extortion and fraud. And there you have a quote at the sentencing on July 21st, 2021, where Mr. Avenatti indicated that he betrayed his own values, my friends, my family, myself. I betrayed my profession. And that obviously harkens back to the Icarus comment. It's sort of a question of just having come too close and then crossed over that barrier where you end up tinging your wings and falling to the ground. What's fascinating about the case is he got a 2.5 year sentence, which was a very low end of the sentencing guidelines that was being fought about in that case between the U.S. attorneys and everyone. And this was issued because the judge had a perception of significant disparate treatment between Mr. Avenatti and his co-counsel, Mr. Gallegos. And the rationale for this disparate situation was unknown to the judge, and it wasn't explained, and the prosecutors didn't explain, and so it remains to this day as an unknown. And so you see there a quote from the judge from the sentencing saying, in any event, it would not be justice for Mr. Avenatti to be sentenced to a 9 to 11 year term of imprisonment when Mr. Gallegos was not even charged. On the next slide, we have some more statements from the judge that help frame the ethics questions that we can start talking about. And what the sentencing judge said, as you can see here, is to state what is obvious from a recounting of the facts, Mr. Avenatti's conduct was outrageous. He hijacked his client's claims and he used those claims to further his own agenda, which was to extort millions of dollars from Nike for himself. But Mr. Avenatti did more than hijack his client's claims for his own financial gain. He outright betrayed his client. When Nike suggested that it wanted the financial settlement to go to Franklin, Avenatti poo-pooed the idea, ridiculing the notion that Franklin be paid an exorbitant amount of money, and that exorbitant is in quotes, and making it crystal clear that the lion's share of any financial settlement from Nike should go to him. And here's another quote on our second bullet point here from the judge's sentencing transcript. And this goes to the variance and the issue of Mr. Gallegos. A variance is also necessary because of Mark Gallegos. As Ms. Perry pointed out, and as I have pointed out previously, Mr. Gallegos was someone whom the government referenced as an unindicted co-conspirator in the criminal complaint and in the original indictment. He was not ultimately charged, and he suffered no consequences as a result of his conduct. And he was a central figure in the criminal conduct. And Gallegos stood to benefit enormously from this scheme because Avenatti's firm and Gallegos' firm were supposed to jointly perform the purported internal investigation of Nike. Moreover, Gallegos, unlike Avenatti, was a highly experienced and prominent defense attorney. Yet he sat by silently at these meetings and on those calls as Avenatti made his extortionate threats. And he participated in a good cop, bad cop routine with Avenatti in which he presented himself as someone who was restraining Avenatti from this headlong approach to a press conference so that perhaps a settlement could be worked out, one in which Gallegos and Avenatti would receive many millions of dollars. So that gives us now an understanding between the audio clips that you can pause if you want, go back and listen to them again if you want to sort of refresh your mind about what happened. But that lets us now have our factual foundation. This is our petri dish to talk about the ethics rules that were triggered by these factual findings of the judge and the jury with respect to the sentencing and the criminal conviction. We can look then at several ethics rules on our next slide here you see, and these are the kind of fundamental ethics rules that we'll start taking apart in a little more detail. The first one is ethics rules that prohibit threats and extortions. And I will use the California rules of professional responsibility because I'm in California, but the rules are basically the same in all states. They come from the ABA's model rules. And so here the threat and extortion rule comes from California 8.4 rule, and this is a duty to not commit criminal acts or engage in dishonesty that's prejudicial to justice. The second major ethics rule that we're looking at is the duty of loyalty to the client, and there's a few sub-rules here that matter. We have the first issue of the client didn't authorize the threats to hold the press conference or know of it, and this triggers California Rule 1.4, which is a duty to communicate with the client, 1.8.2, which is the duty to not use client's information to the disadvantage of the client absent consent. We also have the client not knowing of the internal investigation demand that was being made, and that would obviously trigger 1.4's duty to communicate, among other, obviously, duties of conflicts and the like between the lawyer and the client as to how the case was potentially being resolved. We have the issue of 1.4.1, which is the duty to deliver offers to the client. And one offer made was to give the client more money, which was rejected without communicating that offer to the client. And so it's for the client to know if the client wants more money or not, in that balance that was going on between sort of the two competing aspects of the settlement demand that were being sought. And here's the sentencing judge's comment, which kind of wraps up these different duties from an ethics perspective, and that is that Franklin was never more than a convenient pawn for Avenatti, a vehicle for Avenatti to extract millions from Nike. And this then triggers another set of ethical rules, which is attorney-client relations related ones, and specifically this idea of conflict rules, and it comes from California Rule 1.7, among other rules, of representing both sides as it relates to an offer to be a lawyer for Nike also. Because remember, if one is going to represent their client and be adverse to Nike, and part of the settlement is to represent Nike in an internal investigation, you now have a conflict and a tension, but ostensibly between both clients, but certainly with your first original client, that is there because if you're representing your first client against Nike, you can also get paid millions of dollars by Nike to represent Nike, resolving something that has some relationship to your first client. And so it triggers these rules. So let's look first of all at the extortion rule on the next slide. And the extortion rule comes, extortion itself is defined, at least in California in the Penal Code, as the obtaining of property from another with his consent induced by a wrongful use of force or fear. And here you have a couple cases that we can look at from California, and these are state bar cases or just litigation cases that sort of flesh out extortion as it relates to lawyers and lawyers' conduct, where of course we have a duty, an ethical duty, not to commit any criminal acts or engage in dishonesty or behavior that's prejudicial to justice, and extortion obviously would be. Extortion has been characterized as a paradoxical crime in that it criminalizes the making of threats that in and of themselves may not be illegal. In many blackmail cases, the threat is to do something in itself perfectly legal, but that threat nevertheless becomes illegal when coupled with a demand for money. And here you have another couple cases. Lindenbaum versus State Bar from 1945. For purposes of extortion, it is immaterial that the money which petitioner sought to obtain through threats may have been justly due him. And Gomez v. Garcia, it's a Ninth Circuit case looking at California extortion law, making clear that California law established in 1918 that belief that the victim owes a debt is not a defense to the crime of extortion. So you may be owed money by the person. Literally, they have no defense. They owe you money on the contract. But if you then engage in extortionate threats to get what you're owed, you've now tripped an extortion line, even though there is a perfectly lawful mechanism to deal with the fact that you're owed the money and get the money. And so that's where we decouple from litigation to extortion and threats, all seeking to get money back that we're owed or maybe even not owed in more extreme extortion cases. But that's the ethics rule, and that's extortion that sort of sits in there. Let's look on the next slide at the duty of loyalty to the client. The client didn't authorize the threats to hold a press conference, that I'm going to take billions off your market cap, hold a press conference, I'm going to do all this to you unless I get that. And apparently didn't know of it. And this obviously triggers a variety of ethical issues that exist for us as lawyers: duties to communicate, to not use client information to the disadvantage of the client absent consent, publicizing a whole bunch of stuff that maybe the client didn't want publicized in order to get a tactical advantage. Those are the types of questions that we need to stay toe-to-toe with our client on and keep our clients informed. And this is a type of thing that you can see. It's easy for a lawyer in a case running the litigation where the client's very dependent on you, the lawyer, to run the litigation and to be making a lot of the decisions, that it's easy for lawyers to start making decisions in cases and decouple really from that communication with their client and get approval and acceptance because of the custom of the relationship. And this is one where you can see it's very easy for a lawyer to trip it. It doesn't require some particular maliciousness or something like that. It can just unfold and happen because you're the quarterback, you're running it, the client defers to you, and you start making decisions that may or may not be inimical to the client or what the client wants because the custom has evolved to kind of give you a little bit of carte blanche. And so we need to be vigilant as lawyers on these ethics lines to communicate, to document, and I think the best practice point or tip out of here is when making decisions about do we do this or do we do that in negotiations, pre-settlement negotiations, pre-suit negotiations, communicate with the client, and it's probably wise to communicate in writing so you have a very, very clear record of who said what when, and you're not subject to a client coming back and saying, I had no idea. This is the duty to communicate, obviously in 1.4. The duty to deliver an offer. I mean, this is very, very important. When an adversary offers, what about if we settle and give you more money? That's the type of proposal or settlement idea that has to be communicated and delivered back to the client. And when it's rejected out of hand, which is inimical to the client, because, ostensibly, the client would, all else being equal, we would assume, would want more money rather than less if it's on the table to get money. It's got to be delivered to the client. And to reject it without delivering it to the client means you haven't delivered an offer, and then when it's rejected without delivering to the client and it's coupled with a but give us a bunch of money to represent you in an internal investigation, you've now triggered another conflict and duty of loyalty problem, obviously, and hence the judge's comment. Let's go on the next slide to attorney-client relations. And this triggers some very interesting conflict questions that we alluded to when you end up serving dual masters potentially in a settlement if you're looking to try to represent the very person you're suing or be carved out from being adverse to them again in the future. And this comes up in many, many cases. It comes up in class-type cases or repeat plaintiff-type cases. And this relates to the Ethics Rule 1.7, California Rule of Professional Responsibility, and it's the conflict rules relating to representing both sides, which were triggered here when you start talking about, as a part of a settlement, becoming a lawyer for the adversary of the current client that you're settling, which means if you're going to be paid to represent them, and that's great for you, the lawyer, you're going to make a bunch of money representing Nike, that means are you sacrificing your client's best interests to get that money for you, because the balance of money shifts, obviously. You've got this fundamental duty of loyalty conflict type problem. And so we can look at that. There's one case, State Farm Mutual Automobile Insurance Company versus Federal Insurance. This is California case 72 Calap 4th 1422. And dealing with the prior rule to 1.7, but it's the same content. It was 3-310 then. But basically, the very simple statement of the law here, which is this rule, this duty of loyalty is violated when a lawyer who was retained there by an insurer to defend a suit, and while that suit was pending, the same lawyer filed a direct action against the same insurer in another case without securing the insurer's consent. And what the court said is that with respect to that relationship between the insurer and the lawyer, the lawyer breached the duty of loyalty, and that is sort of just a fundamental, you can't be on both sides of that kind of a transaction. Now, the interesting area where this comes up a lot, obviously, and you see here as the next rule, is Rule 5.6. And these are rules relating to restrictions on a lawyer's right to practice. And that's not expressly what the Avenatti situation was about, but it's very related to what comes up more often, perhaps, in situations. And it's very similar. It sort of tangents to it. But Rule 5.6 basically says that we cannot, as lawyers, unless it's authorized by the law somewhere, we cannot, as lawyers, ever engage in offering or making any agreement that imposes a restriction on a lawyer's right to practice in connection with the settlement of a client controversy or otherwise. And so this is the common fact pattern you could imagine it coming up in. Plaintiff and their class client are in a class action or a putative class action against a big company and come up with a settlement. Maybe it's an individual basis settlement that some dollars are now coming over to that individual plaintiff. And the defendant doesn't want that plaintiff's lawyer to be going out and finding another plaintiff and filing another class action. And so they like the idea of taking that plaintiff's lawyer off the table. And so they say, hey, as part of the settlement, will you come represent us, do an investigation perhaps, clean up the things, which then automatically, obviously, permanently disqualifies that lawyer from ever being adverse to that company again. And so that mechanism that one could think it's sort of too cute by a half, right, is the mechanism that triggers and violates this rule. And the reason it violates the rule is that the rule is built around the idea of not restricting the public's access to lawyers. But it's also illegal to even offer, remember. It's not just if they documented it. If the defendant company says, hey, as part of this settlement, would you be willing to do this? Even the act of making the offer violates that rule, 5.6 as we saw. And so the situation here is that, and the reason it's an ethics violation in terms of the policy reasons that sit beneath this, is that these conflicts of interest arise because the financial interests of the lawyer, as well as the interests of future clients or the current client, become consideration in this very settlement for this existing client. Instead of the only focus being the merits, the value of this client you're representing adverse to that party, right? We're on opposite sides of the V. And so the only thing should be an arm's length transaction based on these current circumstances. And so if the interest of the client is the only interest that we should have, as it is, not our own interest representing our adversary in the future or being able to not be adverse to them, and that's where it's that's why it's the other side of the coin from Avenatti. What's going on then is that we're not focused on the best interest of our current client. And so that hypothetical I gave about the class action is kind of similar, it's the other side of the coin to what was sort of being batted about in that idea. If you look at the melee of the fact pattern, you could imagine that, and we don't know if this is true or not, but you could imagine that the idea is, I will come do an investigation, give me a lot of money, and the part of the value of that from the perspective of the one making the offer to the company is that, and then because I'm representing you, I will be conflicted out, so I won't be able to represent someone else adverse to you, so I can't go find another plaintiff, or if someone calls me, I can't represent them in another suit against you, right? That's kind of the from our class example, the quid pro quo that could be going on, which triggers this sort of violation of your ability to then, since if you're going to be getting a bunch of money as a lawyer for representing them, you're going to really get the most amount of money for your client on this side when you're ostensibly adverse to them, right? We just can't cross those lines ever. And so that's the ethics rule that kind of comes up there. Let's look at now the line between lawful threats and ethics violations versus criminal ones that are violations and ones that are not necessarily violations. And so generally, a filed lawsuit cannot be deemed a threat under federal criminal law. I mean, if you file a lawsuit, you assert your claims, that is itself not a threat. Threats of litigation, on the other hand, can be deemed extortionate if you magnify the risks to the adversary by corrupting the litigation in order to get the price up. And that sort of idea of leverage coming that's purely attributable to the corruption, which is inherently wrongful. And that's a quote from the Chevron versus Donziger case coming out of the Southern District of New York. Of course, the litigation privilege allows threats made with respect to future litigation if the threats about that litigation, I'm going to sue you for infringing my copyright, for example, I would like to settle the case, here's my damages, right? That's a legitimate quote-unquote threat if they're related to the matters at issue and it's not a sham. And we're going to look at a couple cases that explore this. But first, before we look at the Flatley and Mailing cases that explore that, let's just take a quick look at this Chevron versus Donziger case, because it's one that's got this very famous quote in it about getting the price up where the leverage is purely attributable to the corruption, which is inherently wrongful, as opposed to the leverage being something that comes from within the case just because your case has value and that's the way it is and they owe you money. And the basic fact pattern about this, very, very complicated case, but the basic fact pattern distilled for our purposes is that there was a claim against Chevron that was filed in Ecuador by plaintiffs in Ecuadorian courts. And this was claims built around oil and toxic damage from Chevron's drilling that caused personal injury and damage to the Ecuadorian citizens. There was a $10 billion verdict rendered in Ecuador in favor of the plaintiffs. And Chevron, in turn, files RICO claims in the U.S. against the lawyer Donziger, who had been representing these plaintiffs in the Ecuadorian courts. And the U.S. courts then refused to enforce the Ecuadorian order and ultimately found fraud and RICO violations by the lawyer in the prosecution of the case down in Ecuador. And so what the court held, you see here the quote on our slide, is that, put still another way, one engaged in litigation either accepts the risk of an adverse result reached by fair and honest method or settles, and that is fine. But a litigant who magnifies the risks to its adversary by corrupting the litigation in order to get the price up creates leverage purely attributable to the corruption, which is inherently wrongful, which bears no proper nexus to any plausible claim that may have been asserted in the first place, and from which the victim has a right to be free. Now let's look at Flatley versus Morrow. This is 39 Cal 4th 299 from 2006. And here we're going to look at a case where one went over the line on the threats and extortion. In a moment, we'll look at one that's inside the line. So here we have a case where Morrow sends Flatley a demand letter on behalf of Morrow's client, claiming that the client was raped by Flatley and demanding a settlement. Morrow tells Flatley's lawyer he knows how to play hardball, and that if Flatley doesn't pay an acceptable amount, they'd go public. The client and he would go public. The lawyer Morrow said that he had ensured that the story would follow Flatley wherever he went or his troops performed. He was a kind of musician, and would ruin him. And also said, and this is a quote from the letter in all caps, this will become a matter of public record as it must be filed with the court, as it will be part of the basis of several of our experts' testimony. And then it said, any and all information, including immigration, social security issues, and use, and IRS and various state tax levies and information will be exposed also. So it's this issue of saying that you did something to my client and I want settlement, but if you don't settle with me based on what you did to my client, the litigation is going to magnify. I'm going to, there's IRS things, social security things, immigration. It's going to be public record. I'm going to ruin you, those types of things. And so here's what the Court of Appeals said. Morrow also threatened to accuse Flatley of raping Robertson unless he paid for her silence. Morrow argues this threat cannot be the basis for finding of extortion because he'd already reported the rape to the police by the time the letter was sent. In the circumstances of this case, we reject his argument for the following reasons. We look at the pleadings. The complaint alleged that the purpose of the call to the police was not to file a crime report, but to create a sham record of a police report that would make the threats more ominous. She wanted to prevent the police from taking any action that might make the matter public, since any public report would necessarily spoil the scheme to extort a payment to avoid publicity. They held that extortion is not protected by the litigation privilege, because it's the obtaining of property from another without consent induced by a wrongful use of force or fear. So what the court held is that the rules of professional conduct specifically prohibit attorneys from threatening to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute. And fundamentally, this is an example then of going over the line in terms of how one uses the leverage of a case that's within a case and is obviously intra-case legitimate leverage. If your client was victimized, you want to get a settlement, you have the right to say, I was victimized, I would like to get a settlement, here's the money, right? I mean, and have a negotiation, and it can be confidential or not. Those types of discourses are normal. When you go extra case and threaten to go to these other authorities and do stuff in order to corral the person into settling a different set of circumstances, because all that stuff is what you're folding in, that's where lawyers run into these extortion problems, because they're trying to fold in something from another lane into their lane. Watch your lane is the moral of that story. So here's an example of being within the lines, and this is Malin versus Singer, 217 Calap 4th 1283 from 2013. And so we quote here for you the actual sort of statements that then got challenged as being extortionate. I'm writing to you with respect to your outrageous, malicious, and wrongful and tortious conduct. As a result of your embezzlement, conversion, breach of duty, you've misappropriated more than $1 million from my client. My client intends to file the enclosed lawsuit against you and various business entities that you control. As alleged, you and several of your co-conspirators have been embezzling and stealing money from Erasm and Geisha House for many years. As set forth in the draft complaint, you've devised various schemes to embezzle money from the restaurants and clubs you own and manage, not including but not limited to Geisha and Wonderland. You've created a special account or ledger which allows you to keep tabs on how the stolen funds are divided among you and your co-conspirators. We intend, as part of this lawsuit, to seek a full forensic accounting of the books and records of Geisha 2 Hype Productions, LTM, Malin Moore, in addition to your personal accounts. Because Mr. Moore has also received a copy of the enclosed lawsuit, I've deliberately left blank spaces in portions of the complaint dealing with using your company resources to arrange sexual liaisons with older men such as Uncle Jerry, Judge Blank, aka Dad, with a photo enclosed to sort of help identify whoever, and many others. When the complaint's filed with the LA Superior Court, there will be no blanks in the pleading. So the question is then, that gets teed up, is that extortionate? Or is that not extortionate? Is all of this stuff within the lane, within the case, or is it tripping over those lanes? Court of Appeals said no, that was not extortion. The demand letter accused Malin of embezzling money and informed him that they knew how they spent those embezzled funds. There's no doubt that the demand letter could have appropriately noted that the filing of the complaint would disclose Malin had spent stolen monies on a car or villa, if that had been the case. The fact that the funds were allegedly used for a more provocative purpose doesn't make the disclosure of that purported purpose during litigation extortion. And so that's a very good example of the case in terms of identifying the line for you, but also making clear that just because the facts may be kind of sexual and bad for one's reputation and like that, that's not what takes you over the line. If it's relevant to your case, you're using money for improper purposes, we're going to prove the embezzlement, and you happen to use them for, prostitution or whatever, you're allowed to say that, and you're not suddenly being deemed to be extortionate. And so that's a very good case to go look at the letter as being one that, as aggressive as perhaps you thought it was on the prior page, it's within the line. Now we're going to shift to the Stormy Daniels trial and look at the facts as alleged. So this is a Southern District of New York indictment also that came down the same day as you saw earlier, and this is wire fraud and identity theft claims that were brought against Mr. Avenatti. And so remember, Mr. Avenatti represented Daniels originally in getting her out from under that President Trump confidentiality agreement, where there was apparently money that came from President Trump. Then Mr. Avenatti represented her in getting her book contract, and this is where the facts become relevant. Sent a letter to the book publisher, allegedly with her forged signature of Daniels, giving new bank account information to divert the money that the publisher was paying to Mr. Avenatti's bank accounts. And these are for the advances. And so this comes from the indictment. And so this is where the ethics problems we'll look at devolve, obviously, from these wire fraud and identity theft fraud claims, because what's being alleged by the Southern District of New York in the case that ultimately went to trial and led to a conviction is that Mr. Avenatti forged her signature on a document sent to the publisher, telling the publisher, send the money to this account instead. The publisher then sends the money to what's ultimately the wrong account because it's not Stormy Daniels, goes to Mr. Avenatti, allegedly forging her signature. She doesn't know about it. He gets the money. As alleged in the indictment at paragraph 17, he didn't tell Daniels that then he had the money as the money was being paid. She thinks she's not getting paid. She's saying, why aren't they paying me? Go get me paid. And he didn't tell her that he'd already got the money. That's paragraph 19. Eventually sends some of the money to Stormy Daniels. That's paragraph 21 of the indictment. And then further on, he reached out and asked the publisher to prepay another installment, and he did prepay it. And then he took the money, and that's paragraphs 22 to 23 of the indictment. You can look up online as alleged. So here you see the actual indictment, and this I cut and pasted out of the charging document from the Southern District of New York, U.S. attorneys, in the Stormy Daniels trial. And so here you have a paragraph, and it says, on or about December 5th, 2018, victim 1 asked Avenatti, and victim 1, it turns out, it appears, was obviously Stormy Daniels. But in any event, victim 1 asked Avenatti, when is the publisher going to cough up my money? Avenatti did not state that he had previously received the third payment, but instead responded, as for publisher, working them and threatening litigation, they need to pay you the money as you did your part and then some. And then in paragraph 28, the indictment indicates, in or about late February 2019, victim 1 made contact with a representative of publisher 1, who told victim 1 in substance and in part that publisher 1 had previously made the third payment to agent 1. Victim 1 subsequently received from agent 1 documentation indicating that agent 1 had sent by wire victim 1's share of the third payment, i.e. $148,750, to the Avenatti client account on or about September 17, 2018. Victim 1 also received from agent 1 the false wire instructions. So that's the root of it. What's going on is this forgery of a signature, this telling the settling party or the adverse party or just the transactionally related party on the other side of the transaction to now send the money here, getting the money, not telling the client that her signature had been given, that a new account had been given, not telling the client the money came in when the client asks, telling the client that don't have it, but I'm working on getting it, giving wire instructions to deliver the money to now a different account without the client's consent or knowledge. All of those are in sort of the heartland, obviously, of obvious ethics problems that tripped Mr. Avenatti. and obviously led to also criminal problems for this indictment. And so here on the next slide, this is sort of some stuff that happened at trial, and you have the book agent witness testifying, and it's a person by the name of Mr. Janklow. And this is sort of from that prior slide you saw dealing with sort of the back and forth with the book agent, the book company, publisher, in terms of the money. And so the U.S. attorney asks the question, did you believe Ms. Daniels signed this? Janklow says, I did, because it came from her lawyer. Did you ever speak to Ms. Daniels about this? The book publisher says, no. Mr. Avenatti told me to never speak to her about money. He said she got confused. So that was a relevant piece of the testimony, obviously, in terms of what allegedly Mr. Avenatti said to the book publisher in order to sort of hijack the money, but also avoid sort of the publisher going around him, for example, or just going in the back door in some innocuous conversation with Daniels and saying something. Now, Daniels, took the witness stand, and Mr. Avenatti cross-examined Stormy Daniels, trying to make the argument ultimately to the jury that he earned the money and that this was really a fee dispute. And that was sort of the major fault line, it appears, in terms of the defense, was that, look, this is a fee dispute. I was owed a bunch of money. I did a bunch of work. I'm owed the money. I had the right to proceeds. Now, importantly, Avenatti didn't testify in this trial at all, but he did actually conduct the cross-examination of Ms. Daniels because he represented himself pro se at trial. And so here's his question. Didn't you tell the New York Times that watching me work was like watching the Sistine Chapel painted? Answer, that's what you told me to say. Question, and this is sort of another part of his cross-examination, how do you speak to the dead? Answer, I don't know, it just happens sometimes. And that related to some new TV show that she's involved with, apparently, that's got something to do with the supernatural or whatnot. So in any event, it was this sort of cross-examination seeking to make points about various things about her capacity, credibility, or the like, trying to make the point that he was a brilliant lawyer doing brilliant things and the like. But nonetheless, he doesn't testify. And ultimately, given the evidence, it turns out the jury convicts. So let's take a look now at the ethics rules at issue that kind of distill from that fact pattern. And obviously, forgery is at the heartland of all the ethics rules. I mean, there's really never a circumstance, obviously, where we as lawyers can forge our client's signature on a document and get money. I mean, there's never a circumstance under which anyone can forge anyone's signature and try to do a transaction and get money. So that ethics rule is kind of, it's as simple as can be in that sense. But the fact pattern triggers other ethics rules that are important, that even if the conduct isn't as kind of significant as that, there are ethics rules that can come up in much less sort of seemingly innocuous situations in terms of our duties to be very, very careful and scrupulous in accounting on monies and notifying clients about receipt of monies. And so one rule is the rule of professional responsibility, and some of these numbers are the old rules, but there are new rule numbers, but it's 4100, B1 and 3, and it's the duty to notify the client upon receipt of client funds and then pay the funds. And this is an important point. If a case has been resolved, the client is obviously expecting their money. If there's some lag on the money coming in, when the money is received, you got to tell the client that you've got the money. Now, there isn't case law saying that if you didn't tell the client the day it came in and it took you a couple days to let the client know that you somehow tripped a rule. There's no case law saying that. But there is a duty to be aware of when you're receiving money and to be on top of it, and then to tell the client that the money's come, and then to obviously pay the client their share of the money. The other trust accounting rules obviously relate to the duty to maintain client funds. I mean, if you are holding money that is the client's money, their settlement proceeds, that is their money that's in your lawyer trust account. That's not your money to spend, to take out, to borrow against, to just kind of temporarily dip into, or whatever the case may be. It's their money. Finally, there's the duty, obviously, and this comes from California Business and Profession Code, but it's an ethical obligation on lawyers. It's the duty not to engage in moral turpitude, dishonesty, or corruption. And fabricating signatures on documents and lying to clients about how you have not received money when you have received it and taken it and used it, that obviously trips over those California Business and Profession Code concerns about moral turpitude dishonesty, corruption, and the like. So those are the ethics rules that case warrant consideration and looking at. And we can look at a couple of California cases that have dealt with some of these situations in other circumstances where settlements have come in and the lawyers have dipped into the monies, and we can see kind of what happened and what was the punishment for the lawyers. And so this first case is Edwards versus State Bar, 52 Cal 3rd 28 from 1990, and we can look here at issues related to the duty to notify client upon receipt of client funds and to pay the funds. So there's a $5,000 personal injury settlement. The money comes in, the lawyer deposits it in the trust account. So far, so good. What happens is the lawyer sends the client the client's share, and it bounced. So far, not good, because how could it ever bounce? The money should be in the trust account. It shouldn't have anything written against it. In other words, there are no payables out of your trust account that would sit against your client money. So that's the first problem. Turns out the lawyer admitted to financial trouble and had borrowed the money or taken the money out of the account. Hence, when the check was sent to the client's share bounced. But told the client, pay you back, I'm sorry. Months go by, the lawyer doesn't pay it back, stops communicating. Obviously, client at some point puts this in the hands of the State Bar, and there's a State Bar complaint. The lawyer is sanctioned for failing to promptly pay and for misappropriating client monies, as well as a failure to notify. And so the Supreme Court, actually, it's interesting. They said yes as to the first charge, failing to promptly pay and misappropriating funds. But they rejected the ethics charge on the duty to notify, because they said, look, he did notify that the money came in. He just took it. So there wasn't a transgression on the duty to notify. And that's a distinction, obviously, into the Avenatti case, because there was not even a notification. And so the Supreme Court partitioned it out and said, just because he did all these bad things here, you can't say that he tripped that ethics wire too. But nonetheless, he tripped the ethics wires, and the punishment for that was a 1-year suspension for those misappropriation of the monies by that lawyer Edwards in that case. Now let's look at another case, and this is Montalto versus State Bar, 11 Cal 3rd 231 from 1974. And this involves attorney forgery of client signatures now, and monies situations that then flow from forged signatures. Here we have the attorney settling a PI case with the carrier with a check to the lawyer and the client. And so the check was made out by the carrier to lawyer and client. The lawyer now signs for both, attorney lawyer, but also signs the client's signature. Hence, we've now tripped an ethics wire, obviously, if not a criminal wire, and we have a problem. The lawyer gets the client to actually sign a release and then promises to pay the money, but then doesn't pay. And so among other ethics violations that were charged, obviously here there was a moral turpitude charge brought for forging the signature. And the lawyer then was suspended for 2 years. And you may look at it actually and say, like, only suspended for 2 years for forging a signature? You can certainly find other cases where there have been forgeries of signatures, the taking of money, even if the monies were paid, lawyers have been disbarred. So don't look at this case and think it's okay to forge a signature, take some money, pay it back, and you'll only get a 2-year timeout. You're probably permanently disbarred. But nonetheless, that lawyer was only suspended for 2 years. Who knew? 1970s, California Supreme Court, who knows? Anyway, here's a case going back a little further, though, McKinney versus Supreme Court, 62 Cal 2nd 194 from 1964. And here you have a situation where an attorney who's already been previously suspended for misconduct then forges a client's signature on a loan agreement, giving the lawyer the right to use the settlement monies. That lawyer was disbarred, case over, case done. That's probably what you should recognize here in terms of if you're going to flirt with these behaviors, you're going to get disbarred. So the ethics rule is clear. Don't ever forge your client's signature. Don't ever take money out of the trust account. Even if you don't forge a signature, don't borrow from trust account money to pay your bills or do whatever, and then think that you're going to pay the money back. Even if you borrow and pay it back, that itself is a violation. The trust money has to be accounted for properly and isn't a bank for us as lawyers to borrow. Now let's circle back to the Avenatti situation on our East Coast trials and talk about some postscripts. Both of those cases, Nike and Stormy Daniels, are currently on appeal. And also, interestingly here, you can see Avenatti's filed a massive administrative claim against the Bureau of Prisons for the conditions of his confinement that he was held in pre-trial. He was held for 94 days in 10 South, which apparently is a horrendous place for international terrorists and the like in the federal prison in New York. It has 24 hours a day solitary confinement, freezing conditions, no sunlight, and he alleged that the guards gave him a copy of President Trump's book. And the theory of this admin claim, it appears, is that all of this was done to him as payback for his attacks on Trump via Stormy Daniels and the broader kind of presidential aspirations and platform that Mr. Avenatti had. And interestingly, the appalling conditions that Mr. Avenatti was held in were actually noted and addressed by the judge in the sentencing in the Nike case. He actually commented on how appalling and bad it was in terms of the treatment that befell Mr. Avenatti pre-trial as he was awaiting trial. And you can see here on the slide a quote or a copy, so to speak, out of the actual admin claim is filed, claiming personal injuries and emotional distress and suffering, seeking $94 million against President Trump, Attorney General William Barr, and obviously the U.S. government. This brings us to the end, our conclusions, and some of them are simple. Don't engage in extortion and forgery and, stealing client money. Very, very simple, easy lessons. Other lessons, we saw cases on either side of the line. This idea of illegal threats or extortionate behavior and that advocacy line, it's very, very critical to maintain that advocacy line and to not try to leverage a result from extra case issues. And that's a line that if you peel back the onion and go do some more research, you will find there's loads of cases that sit beneath the cases I brought you. I brought you some to help illustrate these points. But in many of the cases, you see these fine lines where what a recurring pattern you see is that lawyers in litigation are engaged in advocacy. It's a war, right? And we are figuring out the weak points, the strong points, how to use leverage. And that process of thinking about strength, pros, cons, what's our leverage, leads to the blurring and falling out of your lane and realizing there are things you can take advantage of tactically for leverage, using them, but you've now tripped into sort of extortion or improper threats. So that line is very, very important to maintain, and to maintain a perspective at all times about staying in the lane of your case and staying within the confines of your case and what the case's facts and law dictate as being the appropriate conduct. The obvious, obviously, is don't take settlement money without consent. Don't forge a signature. That's easy. Let's end where we started with Icarus. The Michael Avenatti case is a great example to look at the Icarus metaphor, as are many of these other cases that you've seen in here, in terms of lawyers who just flew too close to the sun and got burned. I want to make sure, as we always do in these programs, especially our ethics programs for you, that you do not fly too close to the sun. So please, go read these ethics rules. Keep them in mind. Keep them at the forefront of your mind. And this is a fantastic program to have watched and to stay tuned for part 2, because we get to explore the ethics issues with the added layer of how you can go from not just an ethics problem, but to a federal criminal problem, and where you find yourself sitting in federal, criminal prison or state criminal prison. Anyway, that brings us to the end of this program. Stay tuned for part 2, where we're going to shift from these East Coast trials we just saw with Nike and Stormy Daniels to the West Coast trials against Mr. Avenatti, happening here in the Central District of California in the Southern Division down in Orange County, California, relating to additional federal criminal and then ethics questions that we are going to explore in part 2 on the Avenatti trials, West Coast. Thank you very much.